Scrutiny of Big Pharma's role in the United States opioid epidemic intensifies as a judge rules to unseal redacted documents, a jury hears criminal charges against executives, and the consolidated multi-jurisdictional case brought by some 1,500 plaintiffs gets a trial date. That's all up next on Just Saying. Hello there, I'm Allison Cardivold. This is Just Saying. Thank you very much for joining me. First, I want to apologize for not putting out a podcast in January. We were working on this subject matter when it became apparent that there was going to be some movement and some new information available, so we decided to just hold on to it, wait a couple weeks, let things settle out so that we could bring you the most up-to-date information possible. So that's what we did. So I'm sorry you had to wait, but we're here now, and I'm going to give you the gist of what is going on. As always, we have a corresponding article on the website at gistsayyn.com. That's www.gistsayyn.com. And there you can see links and other documentation that I have drawn my information from for this podcast. So you can always do that. All right. So moving forward. In this podcast, we are going to be talking about how 2019 is setting up to be a year of reckoning for Big Pharma. Drug companies have been heavily marketing prescription opioids for decades, providing relief for those with acute pain and making billions in the process. But now that America is in the midst of a full-blown opioid epidemic, state and local governments are lining up to carve off pieces of Big Pharma's profits to help stem the tide of addiction and offset the cost of dealing with the crisis. A jury in Boston federal court is currently hearing accusations of racketeering and conspiracy against employees of Insys Therapeutics, Inc., the company that makes fentanyl. The case involves alleged bribes ranging from speakers' fees to a lap dance. The federal prosecutor in the case says the founder ran his company as a criminal enterprise and, quote, put profits over people, unquote. This case is considered bellwether. If the claims resonate with the jury and guilty verdicts come down, profits over people is sure to become the new battle cry for thousands of lawsuits already lined up against other drug companies. On January 29th, the district court judge in Cleveland, who has been appointed to hear some 1,500 combined claims against multiple Big Pharma companies, set a trial date of October 21st. And on January 31st, the complaint initially brought back in July of 2018 by the Massachusetts Attorney General against Purdue Pharma and members of the Sackler family who own it was released unredacted to the public. So let's start with a little bit of information about the current crisis. In the past 2 decades, more than 700,000 people in this country died from a drug overdose. According to the Center for Disease Control, the numbers of deaths by overdose involving both prescription and illegal opioids is more than 6 times higher than it was in 1999. Meaning 70,237 people died due to drug overdoses in 2017 alone. Of those deaths, 47,600 were the result of an opioid overdose. Again, this is according to the Center for Disease Control, and that means this is an average of 130 Americans a day. Things are so bad that in October of 2017, President Donald Trump declared a public health emergency. Here are a couple of comparisons to put things in perspective. The FBI estimates that in 2017, the number of murders in the nation was 17,284. That same year, the National Safety Council reported that 40,100 people died in motor vehicle crashes. This means 7,500 more people are dying from opioid drug overdoses each year than from riding in or driving a vehicle, an activity in which virtually everyone in the country participates. Those are not good odds. The percentages are out of whack there. The struggle is, we've been here before. The evolution of opioids spans millennia. Opium, the natural source of opioids, is a derivative of the opium poppy plant. The plant's cultivation as a painkiller is nothing new. It was first recorded back in 3400 BC in Lower Mesopotamia, where the Sumerians called it the joy plant. Jump forward to 460 BC, and Hippocrates, known as the father of medicine, wrote of the usefulness of opium as a narcotic. He prescribed drinking the juice of the white poppy mixed with the seed of nettle. For you Game of Thrones fans out there, think milk of the poppy. Its use traveled throughout the ancient empires of Alexander the Great and Rome. The Holy Inquisition cast opium in such an unfavorable light that it disappears from Europe's historical record for about 200 years. Then in 1500, Portuguese sailors were credited with initiating the smoking of opium while trading in the East China Sea. It was a practice considered barbaric and subversive by the Chinese culture, by the way. 27 years later, the drug was reintroduced into European medical literature, described as black pills or, quote, stones of immortality, and they were prescribed as painkillers. In the 1600s, residents of India and Persia began eating and drinking opium mixtures for recreational use. In the 17 and 1800s, the Dutch and then Great Britain ran a very lucrative opium export trade from India, where they had colonized, to China. By the early 19th century, China faced an epidemic that saw millions addicted to smoking the narcotic. When the Chinese emperor tried to block imports, Britain went to war. Twice. The second time, France joined in, all to keep and expand those profitable drug trafficking routes. It was in the 1800s, when men of science ramped up the quest to develop stronger, less addictive opium, that things became even more complicated. The first result of this endeavor was morphine. Though stronger, and partly responsible for enabling advances in surgical medicine, morphine is also more addictive and deadly than the opium from which chemists created it. It wasn't long before doctors in the U.S. were using it as a mainstay to treat everything from the pain of wounds suffered by soldiers on Civil War battlefields to the illnesses of anxiety, consumption, and respiratory problems associated with life in the 1800s. Its use was also heavily recommended to women of middle-class means to relieve troubles feminine in nature. The invention of both the hypodermic needle in 1853 and the synthesized derivative of morphine called, wait for it, heroin, in 1895 led to the next significant evolution in opioid use. And still every time people hoped the next version wouldn't be as addictive. They'd even say it wasn't. A philanthropic group introduced heroin in the United States as a non-addictive substitute for morphine. They sent it out as samples in the mail. And the chemical company Bayer first offered heroin as a cough suppressant. Keep in mind, there was no government regulation of opioids at this point. Anyone who could get their hands on it could put it into any mixture and sell it however they wanted. Laudanum and all sorts of different snake oils would have this drug in there, and sure, at first, it would make people feel better. However, the post-war addiction rate of Civil War veterans and homemakers alike was so high that as the 19th century came to a close, the United States moved to end the use of non-medical opium. The early 20th century saw Congress pass laws that banned recreational opium and its importation, required pharmaceutical companies to list the ingredients of patent medicines on labels, and forced physicians and pharmacists to pay a tax and register to be a distributor. In the 1920s, all non-prescription sales of narcotics were banned in the United States, and addicts just turned to the underground black market to get their fix. By this time, oxycodone had already been developed, again in the hope that it could offer the analgesic effects of morphine and heroin with less physical dependence. Now, unless you're Rip Van Winkle, you've heard how that has played out. The point is, we have been here before. In the 1980s, medical professionals, remembering this history and abiding by the national crusade to just say no to drugs, were reluctant to prescribe any opioid derivatives. However, a growing need for pain management caused the pendulum to reverse course. This happened just in time for the time-release prescription opioids to come to market in the 1990s, and with them came waves of death. The CDC outlines the current epidemic in opioid overdose deaths in 3 distinct waves. It says, quote, "The first wave began with the increased prescribing of opioids in the 1990s. The second wave came in 2010 with rapid increases in overdose deaths involving heroin. The third wave in 2013 with significant increases in overdose deaths involving synthetic opioids, particularly those involving illicitly manufactured fentanyl, or IMF. The IMF market continues to change, and IMF can be found in combination now with heroin, counterfeit pills, and cocaine," unquote. This brings us to Purdue Pharma. The pending criminal case in Massachusetts is not the first time Purdue Pharma has been taken to court concerning the marketing of its drug OxyContin. When appropriately used, the powerful narcotic OxyContin can relieve severe pain for up to 12 hours due to its time-release formula. Upon its introduction back in 1996, the company claimed that the time-release formula made OxyContin less addictive than other opioids like Percocet or Vicodin. Based on this premise, Purdue Pharma launched a massive marketing campaign aimed largely at general practitioners who often had little experience with treating acute pain or prescription narcotics. Sales quickly reached, then surpassed, the billion-dollar mark. Just as quickly, experienced drug abusers and novices alike, including teenagers, discovered that chewing an OxyContin tablet or crushing one and then snorting the powder or injecting it with a needle produced a high as powerful as heroin. By 2000, parts of the United States, mainly rural areas at first, began to see skyrocketing rates of addiction and crime related to the use of the drug. In 2007, Purdue Pharma pled guilty in federal court to criminal charges that it and 3 current and former executives had misled regulators, doctors, and patients about the drug's potential of abuse and risk of addiction over the 6 previous years. As part of the plea agreement, the company agreed to pay $600 million in criminal and civil penalties. Purdue Pharma's president, top lawyer, and medical director pleaded guilty as individuals to the criminal violation of misbranding and agreed to pay $34.5 million in combined fees. However, in a statement released back in 2007, Purdue said that those 3 individuals, quote, neither engaged in nor tolerated the misconduct at issue in this investigation. To the contrary, they took steps to prevent any misstatements in the marketing or promotion of OxyContin and to correct any such misstatements of which they became aware." Unquote. The Attorney General of Massachusetts, Maura Healey, doesn't believe much has changed since 2007. The current lawsuit filed against Purdue Pharma, members of the Sackler family, and other company employees lay out charges of wrongful actions from that point moving forward and claim that they were responsible for the deaths of more than 670 Massachusetts residents who were prescribed Purdue opioids since 2009. The unredacted complaint contains troubling examples of how the company allegedly targeted the elderly, veterans, and patients it deemed trustworthy, mostly because of their commercial and government-funded insurance plans. It claims Purdue Pharma even funded a book and held special events to encourage doctors to prescribe opioids to veterans. The complaint claims that the company also targeted so-called opioid-naive patients without proper warnings of the risks of addiction and death. In a statement following the ruling to unredact the complaint, the AG welcomed Judge Janet Sanders' decision, saying, "For many years, Purdue, its executives, and members of the Sackler family have tried to shift the blame and hide their role in creating the opioid epidemic. We are grateful to the court for lifting the impoundment on our complaint so that the public and the families so deeply impacted by this crisis can see the allegations of the misconduct that has harmed so many." Unquote. In the complaint, the AG alleges to have documents that show the Sacklers approved public marketing plans that would blame people hurt by opioids while the family continued to pocket millions in profits. Dr. Richard Sackler allegedly wrote in an email in 2001, quote, "We have to hammer on the abusers in every way possible. They are the culprits and the problem. They are reckless criminals," unquote. More than a decade later, Kathy Sackler, a board member, allegedly proposed a secret plan to grow Purdue by providing not just the painkillers, but the drug Suboxone that is used to treat those who have become addicted to the painkillers. In September of 2014, she allegedly wrote, quote, "It is an attractive market, large unmet need for vulnerable, underserved, and stigmatized patient populations suffering from substance abuse, dependence, and addiction," unquote. When the unredacted copy of the complaint was made public on January 31st, Purdue Pharma's attorneys responded with a statement of their own that reads in part, quote, "The release of the remaining portions of the Massachusetts Attorney General's amended complaint is part of a continuing effort to single out Purdue, blame it for the entire opioid crisis, and try the case in the court of public opinion rather than the justice system. Such a serious allegation demands clear evidence linking the conduct alleged to the harm described, but Massachusetts fails to show such causation and offers little evidence to support its sweeping legal claims. Instead, Massachusetts seeks to publicly vilify Purdue, its executives, employees, and directors, while unfairly undermining the important work we have taken to address the opioid epidemic crisis by taking out of context snippets from tens of millions of documents and grossly distorting their meaning. The complaint is riddled with demonstrably inaccurate allegations." The statement goes on to say, quote, "Absent from the complaint is the acknowledgement of the fact that most opioid overdoses now result from heroin and illicit fentanyl. In fact, rates of overdoses from illegal fentanyl have skyrocketed in Massachusetts between 2012 and 2016, according to the National Institute on Drug Abuse. Instead, Massachusetts deliberately conflates illegal street drugs with legitimate prescription opioids in an attempt to assign to Purdue liability for all misuse of all opioids. Purdue's opioid pain medicines represent less than 2% of total opioid prescriptions. They are approved by FDA, prescribed by doctors, and dispensed by pharmacists. The material released once again shows Massachusetts conveniently disregarding basic facts about Purdue's prescription opioid medicines, unquote. But at this point, it seems it's not as much about where we are as it is about how we got here. The CDC has attributed the ongoing third wave of opioid overdose deaths that began in 2013 to synthetic opioids, particularly illicitly manufactured forms of fentanyl, also known as IMFs. Which brings us back to the criminal trial currently underway in Boston. Even if most overdoses are now from IMFs in combination with heroin, counterfeit pills, and cocaine, governments want the American companies that have profited for decades from the sales of legal painkillers to pay for stoking the fires of addiction and help them recoup the costs of fighting it. On the first day of the trial against Incest Therapeutics, the prosecutor told the jury that a sales manager performed a lap dance for a doctor to woo him into writing more prescriptions for fentanyl. It was a salacious introduction to the racketeering and conspiracy charges that will be laid out over the next several months against the company's CEO, John Kapoor, and 4 other former incest sales managers. Fentanyl is meant to be prescribed solely for cancer patients. The once billionaire Kapoor is accused of developing marketing schemes that include dinners, speakers' fees, and cash to entice doctors into writing more prescriptions for it. If convicted, he and the other defendants could face up to 25 years in prison. The verdict in this case is likely to reverberate through the thousands that are set to follow. U.S. District Judge Dan Polster recently ruled that crucial claims made in the combined jurisdictional lawsuits brought against big pharma companies should proceed to trial and has set that trial to begin in late October. Manufacturers and distributors will now have to defend against the charges of racketeering and fraud or settle with the various municipal, county, and state governments that have brought those charges. In his decision, the judge wrote, quote, "Plaintiffs allege that defendants have contributed to the addiction of millions of Americans to these prescription opioids and to the foreseeable result that many of those addicted would turn to street drugs. While these allegations do not fit neatly into the legal theories chosen by plaintiffs, they fit nevertheless. Whether plaintiffs can prove any of these allegations remains to be seen, but this court holds that they will have the opportunity to try," unquote. Co-lead counsel for the plaintiffs' executive committee in this national prescription opioid litigation had this to say in a statement about the judge's ruling. Quote, "This ruling is a major step forward for the more than 1,500 communities across the country who have been battling the opioid crisis and demanding accountability from the opioid manufacturers, distributors, and pharmacists that are responsible for creating the epidemic. This is among the largest and most complex civil litigations in U.S. history, and it's moving at an historic rate. In 2019, we expect opioid manufacturers, distributors, and pharmacies will finally be held accountable for the public crisis they wrought when they fraudulently marketed and over-distributed addictive and dangerous opioids. As we enter the trial year, we're glad that Judge Polster has sent a strong message about the future of the litigation, and we are particularly encouraged that the judge has allowed a common law principle, the law of public nuisance, to move forward. For all the communities involved, the goal is the same. It's past time that the counties, towns, cities, and municipalities receive support and resources for the decades-long recovery that lies ahead," unquote. So there you have it. You can agree or disagree on how this should all play out, but this is where we are at. And I'm just saying. This year, as the cases move through the court system, Just Saying will keep tabs and follow up on the developments. To make sure you stay informed, please follow the podcast through the website, your favorite app, and on social media. Until next time, I'm Allison Carterville. Thank you very much for joining us.